1, I have given my affidavit of video that the work has already been stopped and the certified copy has already been provided to the petitioner. The order of the court has already been complied.
Miller, in this collection, my view is that I have already received the certified copy of collector. Miller, in this connection, my view is that I have already received the certified copy of collector dated that is
Where is the affidavit?
yes, 3 date. That is Miller 6th January, 24th February and 17th March. But so far the affidavit filed by BDO is concerned, he has given some false affidavit, Miller. In this connection, I am filing another affidavit. Miller, your lordship may kindly have a glance. In para 7, I have alleged on what manner he has given false affidavit. In your lordship may kindly have a glance on para.
May I place one thing to your lordship? Your lordship, my learned friend is unnecessarily creating something beyond the scope and ambit of the writ. Your lordship may kindly see the prayer. Just a minute. Just a
You may
minute.
have to give your affidavit copy. You don't have it.
Miller,
Your lord, I have filed it.
But we don't have a copy here.
Just now I am giving. Just now. Hard copy I am giving. Right.
No, issuing order to the panchayat officer is one thing.
Yes, my lord.
What about the actual work having actually stopped?
No, that is your lordship may kindly see what his allegation is that there are constructions going on. The video is also there. I don't know why his picture is not coming, but what is happening there? There is no new construction. It is a building. School building is of the year 1992, and it is 30 years old. Wow, your lordship knows due to 5T initiation, some schools we have taken up for renovation, e-classroom, e-library, everything for the upliftment of the standard of the education. And this is a school which is enlisted in the 5T initiative. And we are only doing coloring and all e-classroom, e-library, all these things. There is no construction at all. He is a villager who is against this all these developmental work, and he is creating. And so far as construction is concerned, there is no construction at all. Your lordship, the collector is also there, and the video is also there.
Millard,
Let's 1 minute. Can we hear the collector, please?
Collector, Mr.
Good morning, sir. Sir, this is Collector Baleshwar, sir.
Yes.
Sir, we had been directed to give the certified copies, sir.
That he acknowledges. That he acknowledges his grievance is that the construction work is not stopped.
no,
Sir, on 24th, we had directed the BDO to stop the construction work. And on 24th itself, sir, the BDO had directed the technical team to stop it, sir. And as per the affidavit filed by the BDO, they had stopped it, sir. There was one Narega work that was supposed to be going on, sir. So he had taken action against them also, and the whole panchayat's Narega works have been stopped, sir. So there is no EA from our side, sir. So we have stopped the work on 24th itself, sir.
What is the Narega work?
That was land beautification, sir. So that also doesn't require, sir. That does not come under this purview, sir. But it was a land beautification work, and whatever pictures that the petitioners are showing, sir, those are not related to the construction itself, sir. That was related to
the school. He has put photographs of some school building. What is that?
That is a school building taken under transformation of 5T initiatives, sir.
Okay.
Millard,
Just a minute. My lord is asking the collector why you are interfering.
No, it seems like a floor is being added. It seems like it's not just a repair work as was being pointed out.
So that was before
exactly the work,
sir. That was before this petition, sir. The work started in December itself, sir. January, sir. And the stay was given on 24th of I think March, sir. So meanwhile, there was some repair innovation was going on, sir.
No, these are photographs taken on 29th March.
Millet, 4 photographs. I have already,
I'm just pointing that only to
Yes,
him, sir.
He's,
sorry, Millet.
I don't know why you're
he's so
interrupting.
encouraged. I don't understand why he's so anxiety is there to stop the work of his school.
Have you gone there yourself, or who's? Can you speak to the video?
Video
Video
is-
is here.
Ah. Kindly unmute, sir.
video-
Tell us what's the position.
Sir, namaskar. I am the video Bhanagar. Sir, in 24 February, whenever I received the order from my collector sir to stop the construction work, then I ordered to my technical team to stop the construction work. But the Narega work in March month to continue due to the beautification or any artwork, sir, not construction work, sir.
These are all for beautification of the school under the 5T initiative. Under most school Yojana.
So, what was the order? Like, can we have the collector come back?
Sir,
You had passed an interim order, correct?
yes, yes, sir. I had
What
passed
was the
an
interim order that you passed? What was the purport of that interim order?
So the construction should stop, sir. That was the order, sir. Because Honorable High Court had directed that collector is free to pass an interim order for the construction, sir.
So
That was the
basically, his
prayer from
grievance
the
is that
petitioner.
you should enforce your own order. That's the only grievance in the petition.
Sir.
Can you give an assurance that you will ensure that your own orders are complied with? That's the only grievance in the
Yes, sir.
petition.
Yes, sir. Yes, sir.
All right. Yes,
Sir.
yes. What do you want to say now?
Today, my affidavit, it discloses that your lordship may kindly have a glance on para 7 of my affidavit.
All right.
And the photographs which I have filed in that affidavit
Yes.
as page 7 and 8.
We've seen it, sir. We've not only seen the photographs, in your presence, we have asked him about the photographs. All right.
Yes, yes.
No point now again making us see the photographs.
No, that discloses the place, time and date, Millet.
So you want me to now show it to him on camera? What is it? I mean, how much do you want? You've asked him about the photographs. What more do you want us to do?
No. Now the construction work has stopped. Now I am saying that I have typed that.
An additional counter affidavit has been filed on behalf of by the Block Development Officer Bahanaga, District Baleshwar, saying in enclosing copy of the letter issued to the Assistant Executive Engineer, Panchayat Raj Department, to stop the construction work at the site in question. Both the collector, Baleshwar, and the BDO, Bahanaga, are present online. Paragraph. Counsel for the petitioner has filed yet another additional affidavit dated 9th May 2023, enclosing 4 photographs, all taken on
What?
3 of which have been taken on 23rd March and 4 on 29th March, stating that the construction work is still going on. Full stop. The collector, Baleshwar, present online, has assured this court that the interim orders passed by him, staying further construction activity, is in fact being enforced, and he has given an assurance that his interim orders will be strictly implemented. Paragraph. Counsel to the petitioner confirms that he has received copies of the collector's orders as directed by this court on 29 March 2023. Paragraph. In view of the assurance given by the collector before the court today, The court, no further directions are called for at this stage. The petition is disposed of.
Item number 2.
Obliged, sir.
Item number 2, my lord, may I permitted to withdraw.
Dismissed as withdrawn.
Item number 3.
Here, in the last occasion, the writ appeal was entertained and a detailed order was passed for the government to comply. Now, if my lord would see what has happened, there's a list of dates right at the beginning. I may quickly just place those dates. Page B of after the synopsis. First date is 28/2/2008. The case line was mutated in favor of the present appellants in mutation case number so and so. The order is there at page 103. Then on 4/4/2016, the sub-collector granted permission to the appellants for transfer of the case land and registration of the sale deed. This permission, my lord knows, is under the OLR Act, since the appellants are all scheduled caste people. Then on 4/4/2016, a certificate of nil encumbrance was granted for the case land. Then on 5/4/2016, the sale deed was executed between the heirs of Abhinav Samal and Bhattakrishna Khuntia and was presented before the sub-registrar for registration. 19/5/2016, this honorable court passed an order for consideration of the registration. 23/5/16, appellants made a representation to the sub-registrar requesting for registration of the sale deed in view of the order passed in WPC so and so. 4/6/2016, the district sub-registrar refused to register the sale deed. 10/5, the appellate court, that's the district registrar, he also dismissed the appeal. Then on 30/8/2022, the single judge also said that registration should not be permitted. Now, I would show the impugned order, which is at Annexure 1, page 17.
Basically, he's been relegated to the civil court.
My lords, here they are resorting to 22(A) of the Registration Act. If my lords would see that provision 22(A), that is also quoted in the synopsis. Basically, the honorable single judge records a finding that 22(A) is not attracted. That portion, my lord, may see page 24. Running page 24. This is the para 7 deals with our submissions. Para 7, learned counsel for the petitioners would submit that no doubt an alternative remedy is available to the petitioner, but the same does not preclude this court to exercise jurisdiction under Article 226 of the Constitution of India, which is well settled in law. In this case, the ROR is standing in the name of the present petitioners. Since the land belongs to the petitioners and there being nothing on record to show that the land was government land, neither Section 22(A) nor Section 22(A)(2) of the Registration Amendment Act 2013 comes into play in this case. Since the petitioners have shown their ROR indicating prima facie their right title over the land and possession of the land is not a sine qua non for transfer of the same, the authority could not have refused to register the sale deed on a wrong premise. That the land belongs to the government and there is no order from the court declining title to the government. In such a premises, he submits that the court should set aside the impugned order and direct the opposite party number 3, District Sub-Registrar Jagat Singhpur, to register the said property pursuant to the sale deed executed. Para 8, however, the learned counsel for the state, opposite party numbers 1 to 5, would submit that in this case, there is a serious dispute with regard to the title and possession of the land in question, physical possession being a sine qua non for delivery of land, but dispute being that the veterinary dispensary is located therein, this court without interfering.
You are the purchaser or the...
We are the sellers. Sellers are before your lordship.
What about the purchasers? Where are they?
They are ready and willing to purchase. They are not parties before the court.
No, before the single judge, they were not parties?
They were not parties. This is a dispute between the petitioners and the government.
I thought the purchaser would have gone to register the sale deed and that must have been refused. How will the purchasers not be interested in the matter? If you're the seller,
My lords,
and the dispute is about non-registering of the sale deed,
my lords.
the purchasers must be interested.
Purchaser is in this respondent number 6.
No, even in the writ petition,
My lords.
you included him as a pro forma opposite party.
My lords. That is because the
Usually, in fact, the sellers are not so concerned. The buyers are anxious.
My lord.
In fact, usually the registration charges are paid by the buyer. Usually.
My lord. No, here the issue is that they are saying that a veterinary hospital is there in the case line. Now, pursuant
No,
to
no,
that,
my question is something else.
my lord, locus,
Why is the purchaser not interested in this dispute?
he would be interested.
No,
He's
but
willing to-
nobody's even there before the single judge, he was implemented as a pro forma party,
my lord.
which is a bit surprising. Why is that? How can he be just a pro forma party? Tomorrow, if he doesn't come forward to register the sale deed, then where is all this? I mean, we can lay down pass a whole order. But if he says, I'm not interested, has he paid the entire consideration, not paid it? What's the fact? What are the facts?
That is something which is not a part of
one
this.
has to, because we can't just pass an order without knowing the full
But
facts.
I think today morning, now the developments that have taken place, if I may be allowed to apprise, now on the last 22A is not attracted. That's there. If my lord would see the impugned order, para 9, 26, page 26, paragraph 9. The Honorable Single Judge records a finding that since there are no documents produced by the government, 22A is not attracted. Once 22A is not attracted, there is no question of not allowing registration. So the question of law that falls here is this, that in para 9, the Honorable Single Judge records a categorical finding that it cannot be, that line is towards the middle. Prima facie, it cannot be said that it is a government land and as such transfer is prohibited. So after this finding, registration should have been allowed. And if the government really wants its land back, the government can be relegated to the civil court.
No. You were saying there was some development today. What
Yes.
is that?
Now, after this was shown, my lord may kindly see the order dated 27/10/2022, where the writ appeal was entertained and 3 questions were formulated in paragraph 2. And the Tahsildar was asked to give a report, Tahsildar Jagat Singhpur. 1, 2, and 3, as to how much area was gifted as per the unregistered gift deed by the ancestors of the petitioners way back in 1936. Then total area utilized in possession along with constructed portion by the veterinary hospital. And 3 is area specified in the sale deed to be executed by the petitioners in favor of the
No,
proposed.
I think there is a very interesting twist to this whole thing. Have you seen the counter affidavit of the veterinary officer?
My lords,
The counter affidavit of the veterinary officer.
before the Honorable Single Judge.
No. They filed it in this writ appeal.
In writ appeal.
Copies have not been given. So
I think that is the interesting development. See, internal page 5.
the copy, they have not given us copies.
Actually, they filed a copy of the. I think you have enclosed, is it?
Then it must be before the Single Judge. Page 41.
Page 75. Just come to page 75.
My lords,
Seems to be a counter before the single judge.
before the Single Judge.
And come to that running page
75.
79. Come to the bottom of 78
My lords,
in the instant case.
my lords. Paragraph 7.
No. It starts with section 77 has prescribed.
Para
Internal
7
page
is-
4, running page 78.
It is submitted that.
Well, Section 77 has been prescribed for specific forum wherein the aggrieved party has also, so in the instant case, nobody has approached the civil court for redressal of petitioners well aware that they are not in possession of the lands in question and veterinary dispensary of the opposite is in possession of the lands so and so. The OP number 6 is no way aggrieved by the refusal. This
Read on.
refusal to register the sale deed, it is understood from reliable sources that in the meantime, OP number 6 has expired since 31/8/2020.
That's the whole point. That's why I'm asking you, because it's very surprising for a buyer not to be interested. How will the buyer be indifferent to a litigation like this? He's the one vitally affected by by refusal to register. This obviously has become infructuous.
Because that instruction that is something which is coming up.
No, this was filed
Is it
Way
filed
back
before
before the
honorable
single judge.
No,
Even the
before the
single judge does
honorable
not seem to have noticed this. It is very surprising.
I'll take instructions regarding that. Whether the buyer
This
is,
affidavit was filed on 6th April 2022, 1 year ago.
my lord.
Ah,
No, that
this
is
seems to be a
something.
pointless litigation now.
No,
Unless you now locate a new buyer, again ask for a fresh sale deed and go and ask for registration. What's the point in this? This whole episode is over now.
now this is something which is coming here.
No, this is an affidavit of 6th April. I just happened to see it now.
No, before the honorable single judge, this was not an issue. That's not a ground
Of course, it should have been an issue, sir. I think it was overlooked.
In any case, we will take instructions regarding OP respondent
There's no
number
question.
6.
The whole petition is infructuous then. It was infructuous even at the time it was pending before the single judge.
So, in the meanwhile, the recent development that I was showing, my lords, pursuant to the order
What
passed
is
by
the
this.
point in the Tahsildar conducting all these inquiries if the man is dead? If your purchaser is dead, what is the point of all these inquiries, sir? I think this was overlooked by all of you. Even I don't think you noticed it.
No, in fact,
Nobody noticed it. Your briefing counsel did not tell you.
so far as this is concerned, we can always, if that person is in
It's
debt.
over. The whole litigation is over. Don't say that this is some incidental, unimportant fact which has nothing to do with the case.
That's
This
something.
is everything to do with the case.
No.
If the buyer has died, there's no question of anybody. His spirit will not come and sign the sale deed.
My lords.
No, that's the end of the matter.
No, I don't know if there's somebody else who is willing to buy that instruction.
That's
we
all
can-
later in
That's a separate cause
future.
of action.
That's all some fact of in future. We don't know if it's happening or not happening. Why bother now?
So let me take that instruction.
We'll
my lord.
just leave it all open, sir. We'll say that whether that sale deed, whichever happens in future, we'll go for registration. What happens then? It will be separately decided.
No, this now, if this is something which we didn't.
You may not even, if some buyer now knows there's a veterinary hospital there, he may not even want to buy. So we don't even know if it's going to happen.
No, now the report, what we are told is by the petitioner that there is a portion of the veterinary hospital, some portions are blank. They are willing to
Which is why you need to first go and sort that thing out. All this jurisdiction is all misconceived. You say the challenge in the present appeal is to an order dated 30th August 2022 passed by the single judge declining to entertain writ petition civil 11977 of 2017. Filed by the present appellants along with pro forma respondent number 7, bracket, Tiba Samal, bracket. Questioning an order dated 4th June 2016 passed by the District Sub Registrar Jagat Singhpur in objection petition number 1 dated 5th April 2016, as well as an order dated 10th May 2017 passed by the District Registrar Jagat Singhpur dismissing appeal number 2 of 2016, thereby refusing to register a sale deed dated 5th April 2016 pertaining to plot number 1040, khata number 430 of Moza Panisalia over an extent of AC 0.07 decibels when presented for registration. Paragraph. Apparently, said sale deed was executed by the present appellants as sellers and pro forma respondent number 6 as the buyer. Full stop. The controversy arose as a result of the stand taken by the veterinary department that the plot in question had been gifted to it by the predecessors in interest of the present appellants through an unregistered gift deed, and therefore claiming that the land in question belonged to the government. Paragraph. accepting the above plea, the registration was refused. Registration of the sale deed was refused. Paragraph. The learned single judge is in the impugned order returned a prima facie finding that there is no document to show that the land belongs to the government. Stop. Yet the learned single judge has relegated the parties to the civil court to settle the question of ownership of the land in question, given the fact that possession was with the veterinary department. Paragraph. When the present appeal was taken up for hearing on 27th October 2022, Division Bench of this court required the Tahsildar Jagatsinghpur to examine the records and file an affidavit on aspects pertaining to the ownership and possession of the land in question. Full stop. During the course of the hearing today, the court noted that before the learned single judge, the chief district veterinary officer had filed bracket respond number 5 bracket had filed a counter affidavit where inter alia in para 5 it was stated that the respond number 6 herein, that is the buyer, open quotation, is in no way aggrieved by the refusal to register the sale deed. Unquote, full stop. Further, the DVO stated in the affidavit that, open quotation, it is understood from reliable sources that in the meantime, the opposite party number 6 has expired since 31/8/2021. Full stop, unquote. Although a rejoinder was filed by the present appellants before the learned single judge, it was not a paravise rejoinder. And therefore, the above averment in the affidavit of respond number 5 was not contradicted. Full stop. On the other hand, the submission entirely turned on section 22 capital A of the Registration Act and about its non-applicability, since in any event the land question did not belong to the government. Paragraph. If indeed the purchaser, that is respond number 5, has expired, then the question of registration of the sale deed executed by him at this stage simply does not arise. Full stop. The transaction cannot obviously be proceeded with. Full stop. It appears that with the affidavit having been filed, the affidavit respond number 5 having been filed on April 20th, 2022, much before the disposal of the writ petition. On 6th April 2022, much before the disposal of the writ petition on 30th August 2022. The above fact escaped the notice of the council placing the matter before the learned single judge, and therefore the learned single judge. Stop. In view of the above development, which occurred during the pendency of the writ petition, there was no occasion for the learned single judge to have examined the matter on merits and passed the impugned directions, relegating the parties to the civil court. Stop. Therefore, it is clarified that In the event there is any occasion for the appellants to execute any sale deed jointly with a buyer hereafter in relation to the plot in question, and such sale deed is presented for registration, both the deputy registrar, the deputy registrar or the officer public authority required to register the document will take a decision independent of the decisions which were challenged before the learned single judge in writ petition civil 11977 of 2017. Full stop. For that matter, the decision will be taken independent of the impugned order dated 30th August 2022, passed with the learned single judge in writ petition civil 11977 of 2017. With the above clarification, the writ appeal is disposed of.
My lord, that is sub-register one. Number two is that refusal to register a document by sub-register. That
So
is
all the
applicable.
contentions of the opposite respondents herein are left open to be urged at that stage before the sub-register.
And if sub-register rejects, that is applicable before the ADM.
Yes, all that you can take.
In accordance with law,
No, I'll say never not to follow law. It's obvious, sir.
your lordship has directed to
It's
approach
obvious
the
they have to follow
honorable
law.
single judge.
They'll follow the laws.
Yes.
Your own authority should follow the law. What is the next one? The same.
Same vendor, so same order.
Just put on
The
both.
case numbers would change.
What, sir?
Case numbers would change,
Okay.
but same problem is there.
Same. Correct.
Item number 5.
May I please, Mal? Well, the present petitioner is a senior widow lady Malad at the age of 80 years Malad. She is having a plot at Balangir Malad. And so, taking the advantage of the pandemic Malad, some of the antisocial elements, they've enclosed the plots of the petitioner Malad.
How many of them? Sir, just show me who may be implemented.
Malad, they have not implemented because at that time when the RI was given the report, their name was not mentioned. But recently I have submitted some documents, Malad.
Where is
That
that?
documents recently that RI has disclosed, Malad.
Where is that? Which document?
Submitted.
Which document? sir?
Recently I have submitted, Mal, just 6-7 days back, Mal, I have submitted that.
No, obviously, sir, you should know your paper book more than we do. You have to pardon us. If you are not able to find it in the paper book, you'll have to pardon us.
Mal.
Also not with me. Copy was not with me.
And the representation is pending before the collector. Mal.
Where is the documents to show who are the encroachers?
Mal, I have submitted, Mal. If a date may be given, I can give that.
No, the paper book is here, sir. Just take it out from the paper. Just give him the paper book. Just take it out from the paper books. Very simple.
Mal, here they mentioned, Mal. That is in Odia. Shall I read out with you, Mal?
You can read out for his benefit. What is that document you're reading?
That is page number 1, Mal. That is a document which is submitted on dated 5th April, Mal. 5th April 23, Mal.
Document. Why don't you make a representation now naming all these people?
Yes,
Then they'll,
Mal.
look into
Mal.
it. Counsel for the
Stipulated
petitioner
date
seeks
may be.
leave to withdraw the present petition with liberty to make a fresh representation naming the encroachers who according to him have now been identified by the report of by the revenue inspector.
Yes, Mal.
By the revenue inspector of the area in question. This post office, and after following up with such a representation to seek appropriate remedies in accordance with law.
Mal,
This post office withdrawn with liberty is prayed for.
Mal, a stipulated time may be given, Mal. Otherwise, they will not. They are not going to.
You're there, sir.
I pray, Mal. It is stipulated date, Mal. Because since 2020, Mal.
Correct.
The present
Item number
date,
6.
Mal. 1 month, Mal. Kindly.
Yes.
Item number 6.
Item number 6. We have filed a petition seeking adjournment to file the report. This petition IA number 5062 of 2023 filed on 5th April. We have submitted the reasons for which we are not able to file the report, and we also prayed for 6 months more time, 3 months more time for filing of the detailed counter affidavit with the reports, because from all the districts we have to collect the data and submit the report.
Yes, please.
Only one thing may I point out to your lordship, 7/12/2022 order. Your Lordship has passed the order for complaints report to be filed by serving a copy to the advocate, my lord. That has not been done. And what is the case about?
No, have you
Only
seen this
as
IA?
per 19. Here,
Have you seen this IA?
it amounts to non-compliance and contempt of court as per the direction of the Honorable Supreme Court, my lord. That only is the bar, all the bar associations also were directed.
Are you able to hear me, madam? I'm audible, right? Huh. Do you have a copy of this IA?
No, I have not received.
So that is what I was asking you. Please give her a copy. IA number 5062 of 2023. This is an application
Very important matter. Girls are
filed
debarred
by
from
the
education and all.
state government, seeking 3 months' time for filing a detailed counter affidavit. Stop, Mr. D.K. Manthi, AG explains that the details have to be collected, details of implementation of the Sexual Harassment of Women at Workplace Prevention, Prohibition, Redressal Act 2013 has to be gathered from all the districts and it's taking some time. Stop. Having heard and considered the parties, the court
Small
directs that
request. May here at least that complaints report of this High Court Bar Association, State Bar Council, that may be, and SCB hospital. Because some corporate sectors, they have done it because I have taken information that sale, they are having that.
which respondents are these? Let's come to the cause list.
This is a PIL matter, all the institutions, so that I cannot make all those institutions as a party.
How will they reply then? They are not keeping track of all these PILs.
But this is a PIL that government should implement the as per the act, so that it will be conducive for the women mass to.
Suppose you have the High Court Bar Association.
That is the wording of the Honorable Supreme Court, so that I have done.
No, I'm just asking you a question. You have the Orissa High Court Bar Association. Government will form the committee or the Bar Association will form?
Your Lordship's direction, because here even nowhere it is there.
No, answer the question, madam. Who will form the committee?
I am not on committee. Under section 19, that board is to be made. Board is to be placed in a conspicuous place of all institutions. That is not there. That committee, your Lordship, that is a different matter. They will give information. But that board should be put as per section 19. That is the prayer.
In your High Court Bar Association,
they are not having.
Who will?
Bar Council not having. High Court office also not having.
So who will put the board?
Your Lordship, ample power.
We have to put the board.
The direction may be given. The registry may do it.
Registry is made a party. Simple.
Well,
logic is this. If you give a direction, it has to be to a party.
Person to be added as parties.
Sorry?
So the 1,000, because so many institutions, every temple, all the hospitals, all the schools, educational institutions, everywhere that board should be put in a conspicuous place. That is as per section 19. That direction was given. That your compliance report means that board can be put. How much money that will be, it will be spent.
No.
And all the institutions I am telling, because we are not doing
then
it, how can we advise
we'll
others
simply
to do
dispose of this petition saying everybody responsible for putting boards should put boards. That's it. Then you'll be very happy.
Direction.
We'll be very happy.
Take, no.
Why not? That's what you want. You're saying don't ask me to impede people. You pass a direction, everybody will obey it.
Yes,
so
that everybody.
We'll dispose of this.
Your Lordship's directed that compliance report that all the institutions.
Okay, so we'll say all institutions in Odisha should file compliance report with you. Should we say that?
Copy should be given to me and that should be filed.
So we'll actually say all institutions. We'll now say all institutions in Odisha should ensure that provisions of this act are complied with and submit compliance reports to you.
Complied with. That report may be
submitted to you.
Your Lordship has ordered that copy.
You think this is a PI because it's a serious matter?
Yes.
This is why we're asking questions. No, 1 minute. We are seriously asking you questions because you're a serious practitioner, right? You want effective orders from the court. Suppose we pass a direction like this, that everybody in Orissa should obey the provisions of the Act and file compliance reports with the counsel for the petitioner. You'll be happy?
No, not that way, madam.
No, no, you
That
tell us. You
order-
tell us. You're such
not
an experienced.
Time has been shut for and without
You're such
serving
an
a copy.
experienced
That is-
counsel. You're such an experienced counsel.
No, I want an effective order. What
How,
this order that
teach us,
representation.
teach us. We are completely
Discussion.
illiterate. Teach us how to pass effective orders. Assist us as counsel now. You're an officer of the court, correct?
Some time may be granted 1 month or.
So in 1
not
month,
3
everybody
months.
responsible for implementing the act should implement.
Strict order should be passed so that it can be complied with.
What is
Not
that?
a heavy
What is
cost.
that, madam? We are asking you, what is the meaning of an effective order? What is the meaning?
So that it can be carried out. And if they will not carry out.
Okay, I will dictate an order. I'll dictate an order now. You tell me if it's an effective order.
We will not go into all these things. Well, I need that if your honor wants to give 1 month time, that may be given. Because already 3-4 months have been given. Another 1 month does not matter.
I don't think you realize what it is to pursue a PIL. According to you, you can just draft a 4-page petition, leave it in the court. Court will take care of the rest. Correct? That's our duty. Your duty is only to file one petition.
Yes, my lord. I bowed down that your lordship may pass.
And then if we pass an order which makes no sense, then you're the first person to go and say, listen, the court has made past orders which nobody can implement.
No, good. The earlier order was passed. See that how slow the government is in taking
All
steps.
right, you see, having heard and counsel the parties, the court extends the time for the government to file a compliance report in the form of an affidavit up to 3rd July 2023. No further time will be granted for this purpose. This IA is disposed of. In the main matter, you see list of that early thing you say, advance copies of the affidavit would be provided to counsel the petitioner. Then you say in the main matter, list on 10th July.
Item number 7.
Item 7, may I please see? In that case, let's see the.
I have filed a caveat, copy has not been served on me. My lord, I have filed a caveat petition, copy has not been served on me. Even my name appears in the list.
It's a PIL matter. My representation is pending before the opposite 2 to 4 miles.
No, but I think he's
I should
appearing
know
for
what
opposite
is the
party
matter.
number 5.
I should know what is the matter, my lord.
You have to serve a copy.
I will solve the copy.
Counsel petitioner undertakes to serve a copy of the petition on counsel appearing for opposite
private
number
offer
5.
fix
on
on the
Tegate
private
today itself.
offer regarding the
List of-
government land ministry.
1st May. Oh, sorry, 2nd May. Sorry, I think 1st May is better. 1st May. List on 1st May.
Item number 8.
May I please, my lord?
Drinking water.
My lord, in the era of reverse osmosis,
See, this is a very good way of first file the petition with the newspapers, then file it in court.
no, my lord, this is a fact, my lord, because we have.
I read about this. I read about this petition some 2 weeks ago. I don't know when you read it.
My lord, it is the demand of the hour. Scorching summer is ahead, my lord.
I know. So I'm just saying, first filing has to happen in the newspaper offices, then filing in court.
No, my lord, this is the.
Yes.
My lord, there are. This issue has been raised.
In fact, next step will be Mr. Mohanty will file his
No,
reply
but it is
with
ASA.
newspapers.
I am not.
Then file it in court.
My lord, against the almighty state government, it is against the Union of India, my lord. The ASI has to reply, my lord, because in the era of reverse osmosis water purifier system, the World Heritage Site is supplying water through a hand pump. So, my lord, my prayer is to install 2 reverse osmosis plant and, my lord, kindly have a glass to page 10, my lord.
All right. You see, the Karnataka Bar Association has come forth with the prayer for provision of adequate potable drinking water to the thousands of visitors.
Per day footfall
the-
is more than 3,500, my lord.
To the Sun Temple at Konark, which is a UNESCO heritage site, right? It's a UNESCO heritage site, or
Let him serve
My lord.
extra copy, my lord, I will take
My
it.
lord, he will take instruction because summer is ahead, my lord. Already it is 40 degrees Celsius, my lord.
a
So, my lord, if-
representation was made to the Archaeological
He
Survey
has
of
not
India,
repented, my
bracket
lord.
ASI, Bhubaneswar Circle, on 26th January 2023 by email.
Let him file a fresh repentation, my lord. That repentation is not correct, my lord.
my lord, two repentation. One is
But,
actual.
he has sent the repentation through mail, my lord, but there is no attachment in that mail which he has annexed in the petition, my lord.
He'll give you
Let him
copies.
file a fresh repentation.
He'll give you copies. If the council appearing for ASI is directed to immediately supply to his client, the ASI, a complete copy of the petition,
My lord,
which is going to be served today itself.
today itself. My lord.
Do it right now in our presence,
My
sir.
lord, I will get it, sir. Today I will serve because next case we are there in another case.
Today itself on council for the ASI. The ASI will, after hearing Mr. Shivashankar Mohanty,
No, my lord, the president could
President.
I will not go there.
President of the Konark Bar Association, pass a reasoned order, and better still, arrange to provide the drinking water facility by installing, now there's an exhibition for some Israeli companies. Have you seen that?
My lord.
You went for the World Cup hockey. You went or not?
Yes.
That outside in that stalls, they were having that. Some Israeli companies have come and demonstrated. Have you seen that? They get water facility through air. They're able to
Instant.
condense. It's quite some remarkable thing. Anyway, by installing reverse osmosis plants at a suitable place in the complex, and also water dispenser points. These are essential because the summer season has already commenced and there are considerable footfalls in the monument. The decision in this regard be taken and implemented not later than 1st May 2023. At least have the syntax tanks, all that you can start.
Yes, okay.
That's all nothing at all. The petition is disposed of in the above terms.
Deeply obliged, my lord.
Item number 9. 9 may please. In that case, let's see the present petitioner is praying to opposite parties regarding transfer of present principal of Odisha Adarsh Vidyalaya. That
PIL service matter. Transfer upon employee of the institution.
my representation also pending.
No,
That opposite two.
You see, the CILs concerning service matters are usually not entertained. We'll stop leaving the petitioner to seek other appropriate remedies as may be available to the petitioner in accordance with law. The petition is disposed of.
Item number 10.
Mr. PIL, my lord. Adarsh Vidyalaya is being constructed over a Gochar land. Some objections are made. The authority are compelled to restore the land to its original status of Gochar, my lord, by annexure 5 and 6. Thereafter, they are going on constructing the land, constructing the building. Annexure 5 and 6, lordship may see for a moment.
Why haven't you made a representation?
But that was earlier, my lord. That was earlier.
No, now why haven't you not made a representation?
Once it was restored, and thereafter they are construction, thereafter I have come without making any representation. Earlier I made a representation.
No,
and village.
Where is that, sir? Now you
There
have
is no
implemented some
representation.
builder also, you have contractor, you have implemented.
Yes, contractor was made a party, my lord.
What's the point? Contractor is simply executing his contract, sir. He doesn't have an independent say in this matter.
This contractor by direction of the opposite party number.
You see, the present petition, copy of which is already available with Mr. Mohanty, will be treated as a representation. Will be examined by the
Collector.
Collector Cuttack, bracket opposite party number 4. And after giving a hearing to the petitioners, a reasoned decision will be taken and communicated to the petitioners not later than 1st June 2023. Stop. It will be open to the collector if he considers it necessary to issue interim directions pending the final decision. Stop. The court clarifies it has not expressed any view in the matter. The petition is disposed of it about this.
Item 11.
May please. The petitioner in this writ appeal, my lord, has approached this honorable court against the order of Honorable Lord and Single Judge, Annexure 6, page 82, my lord, which is a non-speaking order, my lord, and without discussing any point which has been raised in my original application, as well as in counter, as well as in rejoinder, my lord. I may place this order, my lord. Lord and counsel for the petitioner submits that the petitioner is no more in employment. This court finds there has been a repeated direction of a tribunal in successive original application at the instance of the petitioner, thereby directing for consideration of the case of the petitioner against future vacancies. It appears to
No more in employment meaning what? You retired?
I'm not retired.
No more in employment means what?
Not in service.
Yes, as per in pursuance to the court order, I have been engaged as a casual worker. Thereafter, due to no work, the authority has removed me from my service.
Since when?
That is at annexure.
18,
Give us the
12,
date, sir.
18/12/1995.
That is at annexure. Annexure 9 of page 36.
Sir, I'm asking for a date.
That is date 15th March 17. 15th March 17.
What? What is 15 March 17?
As per the direction of the Honorable Tribunal, the authority has given me in casual employment, and thereafter they will place me out of employment.
No, you've been working since, between what dates have you been working?
That is at annexure.
Sir, don't tell me annexure, please give me dates.
Page 33.
You give me dates, sir. What were the dates between which you have been working?
My lord, he has engaged in the year 26/11/1989. Has engaged. And he has been in service till 1995. Thereafter, he is out of employment because the government, the authority has selected him for appointment in due course of selection process, madam. Due to ban order, his case has not been considered. Even four persons are participated in that interview. 3 persons have been engaged. Even if ban order is there for this person, the issue letter has been issued by the government. We cannot be appointed due to ban order. He remains silent, basing on this. Thereafter, he has filed another way. In that way, it has been directed. Please.
I'm not able to. You want me to fill in the blanks? There are too many blanks in your narrative. We got one date, which is what? 18/12/95.
95.
What month? What date?
That is in the year 1995. He has out of employment.
No. The year has 365 days, I suppose. Can you give me a date, sir?
Exact date. The date is not exact. Date is not.
After 95, he's been out of employment.
After 95, my lord.
So between 95 and today, how many years have passed, sir?
My lord, after 95.
No, you tell me. My arithmetic is actually quite weak, sir. So you'll have to help me in that. How many years since 1995?
95 means now 23. Minimum 27 years has already been passed.
27 years.
Years has already been passed.
So this 27 years, what is the narration of facts for 27 years?
He is only filing case after case after case before the.
So if we write a judgment today, we'll simply say petitioner was filing case after case after case.
Well,
no need to give dates.
3 successive OA has been filed, and in
so we simply say successive OAs was filed case after case after case. Very convenient for us. We don't have to give dates. You don't have to give dates. Very convenient for us. That poor man, when he reads our order, he'll say, what is this order? The judge is simply saying, I filed case after case after case, successive years. The judge does not even bother to tell me how many cases I filed, over how many years I filed.
There are 3 applications has been filed in State Administrative Tribunal.
No dates again.
Date is there in that.
Basically, you're saying, you two judges, what are you doing? Do some work. You're saying.
First original application in OA number 739 of 1996, judgment on 15/9/11, my lord. There, the Honorable Court has directed, consider his case, relaxing his age for appointment, for consideration of his case.
Then what
Thereafter,
happened?
they have not considered. Then there is an interview. In the interview, he has participated. 3 persons have been appointed. His case has not been considered. Thereafter, he filed another way. That is 701.
Is that the way to do it, sir?
Hello?
Is that the way to do it? Because I've practiced, I think Justice Satpathy has also practiced. If we got an order from the court and somebody did not implement it, we used to file a contempt. I don't know what you would do.
Filed contempt. In the contempt also, direction is given that his case can be considered. Thereafter, he is not considered. Thereafter, again, he filed a case. That
is the problem, sir. Why did you allow the contempt to be closed? Contempt should normally not be closed, no, till the order is implemented.
Well, only it is a mercy application before my lords that he has already been worked for a pretty long period in the.
No, how do you see once
he has been selected in the due course of selection procedure due to ban order, his case has not been considered. Whereas other 3 persons has been considered, this poor man cannot be considered. And he is only asking for any employment as a contractual employment.
What is his age now?
Age is now more than 40. He's engaging
My
in
arithmetic
28.
is all going wonky, sir. I don't know what your
In the
arithmetic
year
is.
1989, his age is 28, man.
In 1989, he was?
Age 28.
Okay, so today he'll be only 40.
Near about 50.
I thought, sir, now your arithmetic is becoming very, very bad in this process. I think I am a very poor influence on you. I have bad arithmetic. I have made your arithmetic worse.
Well, I know that his age has already been crossed to get any public employment. Because if be any contractual employment, he can be.
Without knowing what his age is, we simply tell them, sir, give him contractual employment.
Sir,
you will be happy.
My lord, his age is.
We'll allow this petition saying Mr. Patnaik's submission is fully accepted. Petitioner be given contractual employment. Petition disposed of. You are happy? Are you happy, sir?
Happy is giving any contract because he's now is not his age to give a regular employee.
You don't know the age. I don't know the age. We're very happy then. Without knowing his age, we'll tell them give him contractual employment. Petitioner will be very happy. You will tell him, sir, you have succeeded. Court has fully accepted our plea.
Age is more than 50, my lord, 52 perhaps.
So 60 is also more than 50. 70 is also more than 50. Everything is more than 50.
Poor man can do what the poor man can do, my lord. He is
poor man can tell you what his age is. You can then tell us what his age is.
More than 50 years.
Poor man will tell you, sir, I am above 50. Mr. Patnaik will tell the court, sir, he is above 50. The court will write down, he's above 50. Not knowing what his age is. Tomorrow they'll find out he's 72. First ground in appeal in Supreme Court will be, sir, 72-year-old man has been asked to be given contractual employment.
My lord, his date of birth 26/11/1989, my lord. That is in Annex 7. He has already mentioned in.
His date of birth is 1989.
89.
On the day he was born, he was taken into employment.
I'm employed in the year of 28.
I thought 10 minutes ago you told me that he worked from 1989 to 1995.
The date of birth is 85/1971. So I'm sorry, my lord. Date of birth.
I don't know whether you're sorry. We are really very sorry, sir.
85/71, and he has joined in the 89. Man.
I think, Mr. Patnaik, as we go along, you're discovering facts. You had no time. You're a very busy lawyer. You had no time to study your brief. Unnecessarily, we've been asking you questions. We have to give you time.
28
because
years
you're not in a position to tell us
service,
facts. You're not in a position to tell us facts.
Well, at 28, in the age of 28, he joined in the service, my lord. His date of birth is 85/71. And he is working from 89 to 95, my lord. And thereafter, he has filed a case for his service, for his engagement and regularization. Even if a court order is there, 3 successive OA has been filed, order is also in his favor. In each order, it is mentioned that his age to be relaxed while considering for his appointment. In each order, the court has directed his age to be relaxed because he has discharged duties for pretty long period for the department. So now he is now in the age of 52 years. So in this juncture, I only pray that any casual, any contractual employment the government will provide can survive for last 8 years.
What is the prayer in your original petition?
My lord, in my original petition, that has been again, while that original application before this court, I filed a miscase for modify my prayer for engagement. That is at page.
No. When you filed the petition, when did you file it before the OAS?
When I filed the petition
OAT.
before the tribunal, my lord.
When?
So my prayer is to direct the respondent to regularize the service of the applicant.
How? So without his being in employment, the tribunal should regularize his service. This is new concept.
My lord.
No. Do you find it strange? I don't know.
No, sir. It cannot be.
Cannot be, no?
If not in service.
How can he regularize? Very good question. So why did you file such a petition? So where did you file such a petition?
Well, file amendment petition before this.
You ask for a prayer like that, then you amend the prayer.
Why I give you at page 73, page 74, I have already prayed before the court while the case is under consideration before the court.
What did you pray?
For adjudication.
What did you pray? Where is that amendment application?
That is at page 71, annexure 5. Further affidavit on behalf of the petitioner, my prayer is that page 73, since petition was selected through the due process of selection while working on casual basis, and 3 persons were appointed against Group D post, and a petitioner could not be appointed due to the ban order as intimated by order dated 29/11/2011. It is prayed that the Honorable Court may kindly be pleased to direct the opposite parties to consider the case of the petitioner for appointment against Group D post instead of regularized as prayed for in the petition. So that petition is before the.
So you don't have to file an amendment application, is it?
I filed this petition before the court.
This is petition or affidavit?
See, additional affidavit.
Affidavit, application, all same. I think you can write a separate procedure code, I think.
So keeping this in mind, to the court, the court has passed order that his case cannot consider for the case of petition against future vacancy. That is also my prayer in that additional affidavit.
What happened to this additional affidavit? It's not an application. So what will the court do? How can the court grant relief on this affidavit?
Only your lordship.
Everything is mercy. Everything is mercy. We are actually a Lok Adalat then.
52 years, my
Lok Adalat. So whatever, whether facts justify it or not, whether proper petition filed or not, whether proper application prayer made or not, whether applications filed or not, we should say poor man. First line, petitioner is a poor man. 2, all of Mr. Patnaik's prayers are allowed. Only ground. No need for law, no need for facts, no need for legal assistance. See what we are doing. And when we pass orders like this, it cannot survive for even 3 minutes. Somebody reading an order will set it aside in 3 minutes. No facts, no law, nothing. What is the law? A person out of employment should be regularized. Is there a law for that?
No.
No law. Then after 5 years after making such a prayer, you suddenly decide, oh, the prayer is something wrong with the prayer, correct? Then you start filing only an affidavit. You don't file an application. And you say that affidavit should be allowed. How will the affidavit be allowed? Difficult, no? Cannot. So without the petition being amended, without the prayer being amended, somehow it should be allowed. Difficult. If we ask you questions, the only answer is, sir, he's a poor man. We are not helping that man, sir. All of us, three of us sitting together, we cannot help him because there's no law. There are no facts. What do you want to do, sir? You say the appeal is directed against an order dated 16 July 2021, passed by the learned single judge, disposing of WPC bracket OAC number 1029 of 2017. Paragraph. The above petition, which was initially filed in the Orissa Administrative Tribunal, in 2017, prayed for a direction to the opposite party, that is Director of Horticulture, Government of Odisha, to regularize the services of the appellate against one of the vacancies in the department. Stop. Paragraph. Interestingly, the above prayer was made at a time when the appellant apparently was not in service. Full stop. As the facts transpired, he had been engaged as casual laborer, public attendant in the department intermittently between 1989 and 1995. Full stop. It was inconceivable that he could pray for regularization when he had ceased to be in service since 1995. Correct. Correct. Apparently realizing this obvious error, counsel for the appellant appears to have filed an single quotes further affidavit unquote, in the High Court after transfer of the application to it on 13 July 2021, seeking to substitute the prayer with a direction, open quotation, to consider the case of the petitioner for appointment against Group D post, full stop unquote. Clearly, since this was only an affidavit, the prayer in the writ petition remained unamended. Paragraph. During the course of submissions today, counsel for the appellant further modified the prayer to say that a direction should be issued to the opposite parties to employ the appellant on contract basis or casual basis. Paragraph. Counsel for the appellant was unable to explain what is the legal basis for making such a prayer, except by saying that the appellant is a single quotes poor person, unquote. It appears that there were earlier rounds of litigation involving the appellant And a similar period appears to be made long ago before the OAT on 15 September 2011 in an OA filed in OA number 739 of 1996. Full stop. The OAT directed the authorities to consider the case of the applicant for appointment in any Group D post, allowing him to participate in the selection process. That's all. Instead of following up on that application to its logical end, the appellant appears to have started another round of litigation in 2017. Paragraph. In the above background, since the release prayed for were incapable of being granted, the learned single judge has rightly rejected it. Full stop. With the facts being sketchy and the legal position not even pleaded, not even placed before the court, the legal basis not even placed before the court. Come on. The impugned order of the learned single judge does not call for writ of appearance. The writ appeal is accordingly dismissed.
Item number 12. Item 12.
Item 12 already requires filed, but in late. Plus, we issued notice on 31st March, requires filed in the meantime.
Sorry?
Requires filed in, you'll also issue notice on 31st March. So, the noting is that the noting requires
All right,
not.
the requisites filed on 31st March be utilized for fresh notice to be issued. Returnable. But what is this matter?
The matter regarding regularization of a contractual employee, the very fast the matter has been disposed of.
No. This is different from any other batches.
No, this is a first case.
No, of this batch. No,
Of-
there's no batch.
No.
All right. Returnable 5th July. Interim order to continue.
Item 13.
This is also regularization, a part. This is the first case also.
All right. This makes this 6th July.
Right.
Notice returnable 6th July. There should be interim order.
Item 14.
Lordship has fixed a similar matter to 6th July. I'm giving order.
Same order. All right.
Item 15.
A similar matter notice was issued by this honorable court.
Yeah. All right.
Item number 16.
16 lordship has fixed to the 11th May.
Item 17.
25th April.
Same.
Item number 18.
Item number 18, Your Lordship, the client does not want to pursue the matter anymore. I have filed a memo to that effect.
Memo taken record. This post office not pressed.
Much obliged.
Item number 19.
Rehabilitation 30th August.
30th August.
Item number 20.
Item 20 contractual matter regularization 11th July.
11th.
Item 21.
That is purchase 14th September.
Item number 22.
22, I am for the opposite party. I have appeared through caveat. If your lordship look at your lordship's order, my lord, this institutional, my lord, this council, several orders have been passed, my lord. If you're, I'm handing over to your lordship's, my lord, my associate is there.
Appellate in discussion.
Your lordship's already disposed of, my lord, based on your lordship's direction, my lord, the honorable single judge passed that order. And in the meantime, my lord, orders have been implemented. I have given one copy of Sabita Sahu, my lord.
Right.
I'm going to read the bill now.
Same order.
It's a sweeper.
Whatever that, there it was what, watchman. Same orders. In view of the orders passed with this court.
But sorry, my lord. In fact, it has not engaged against any sanction post. It was illegal appointment. That much submission may be recorded.
Same for all those matters also.
That's correct.
In view of the orders passed with this court on 6/12/2021. In orders passed involving the same institution, appellate institution, on 6/12/2021 in writ appeal.
Yes.
Numbers 231 of 2016 and batch bracket Vice Chairman State Council for Technical Education and Vocational Training versus Sri Brajakishore Mohanty bracket 25th August 2022 in writ appeal number 363 of 2021 bracket Vice Chairman State Council for Technical Education Vocational Training versus Manoj Patra and others. The present writ appeal is also dismissed. Or
Delay was there. Let's put delay be condoned so that.
or delay stand.
Item 23.
23, my lord. Lordship 15B against that with application was maintainable. My
Sorry,
lord has
please.
all against 15B, my lord, the writ has been filed. The honorable single judge said the writ instead of writ that is should be filed. Your lordship has also interfered in some cases and adjourned to 18th July 23.
Towards the order.
That maintainability of
Same order. List along with order.
Item 24.
24, my lord, 14th September.
First
section.
Order.
Item 25.
I think 25 kindly pass over.
Pass over.
Item number 26.
Item number 26, 27, 28, 29, 31 and 32. All the matters of lordships are fixed to 24th July.
24th July. All right.
Item number 30.
My item 30, rehabilitation number 30th August.
30th August. All right.
Item number 33.
33, my DLR matter, the 25th April.
25th April.
Item 34.
34 also 25th April.
All right.
Item number 35.
At
36.
36, your lordship, some defect is there, time may be given to the defect. Limitation is there, man.
Defect copy is stated. 36 copy only 37 days. 57. Anyway, COVID will be there. This has not become infructuous. What is the ground?
Huh?
What is the ground on which you are challenging the impugned order?
Yes, ma'am. I have challenged the rejection order, your lordship. I have challenged the rejection on the ground of that they have rejected on the ground of that you have not qualified in BA as Hindi and also in MA in Hindi, a less percentage mark in Hindi. In the meantime, similar judgment has already passed, man. They have quashed that circular, and that is kindly see, your lordship.
So come to the impugned order.
Yes, ma'am.
Impugned order is page 45.
Yes, ma'am. 45, Annexure 9.
What does it say, sir?
I am.
It is your submission, sir. You say it is recorded there. Learned counsel, the petitioner states by flex of time, the petitioner has become infructuous.
No, man, I have challenged the rejection order. Your
No,
Lordship.
no. Is this statement correct or incorrect?
That part I have not mentioned before that is effects of time that has not been.
You have not said this.
No, man.
Then you
I
file a review
filed
petition, sir.
Yes, ma'am. Your Lordships, I have
Say
also
the
filed
impugned order reads as under reproduce the impugned order page 45. Today, counsel of the appellant states that he has never made a statement as recorded in the impugned order. Paragraph. If indeed that would be an error apparent on the, if indeed this submission is right, it would be an error apparent on the face of the record, for which the appellant should file a review petition, permitting the appellant to avail that remedy. The appeal is disposed of.
37.
At 37 job contract 14th September.
38.
38 also 14th September.
Item number 39.
39 25th April.
Yes.
Item 40.
That on behalf of Mr. S.K. Karan, kindly have 2 weeks time for removal of the defects.
List on 26 June, defects be removed.
Item number 41.
Milord, may I please your lordship? The order challenging the honorable single judge order under section 15B.
That is posted to that date. So it's on July 1st week. All
10
the
July.
Yeah.
That same order is that earlier.
Item similar.
12th July, is it?
12th July.
12 July.
The same.
Status quo shall be maintained till then.
12th July is available.
Okay, 18 July.
Item 42.
Sartapada 8th May.
8th.
Item 43. Item number 43.
That was dismissed.
Item number 44.
44 my work on 14th September.
14th September.
Item 45.
45, my lord, I pray 1 week time to remove the defect, my lord. Death chart and synopsis, my lord.
List on 1st May, defects be removed.
Obligement.
Item 46.
14th September on job contract.
Item number 47.
Job contract 14th September.
14th September.
48, 49, 50 also 14th September.
All right.
Item 51.
51. Next week, madam. Mr. Misra will do it next week.
Why? Why next week, sir?
Mr. R.N. Misra will do this case next week. Is today. Next week, any.
At the request of counsel, the appellant list on 20th April.
My lord, was fixing it
20th April. Item 52.
May it please. Lord, my lord had asked the single judge to decide this matter and then keep it. It's now fixed on 26th of April.
All right. All right.
So my lord may have it later.
All right. Court is informed that the matter is listed before the single judge on 26th April 2023. List on 22nd June.
My lord, can it be first week of July if it's convenient?
All right.
I think that's 3rd July if possible. 4th July.
4th July. 4th July.
4th. Very grateful.
All right. All right.
Diplomat. Item number 53.
Same.
Same. All right.
Item number 54.
No, 55.
54, sir.
None appears dismissed.
Item 55.
My lord, on behalf of myself, Learned Counsel, my Kali Prasanna Mishra, I pray, my lord, 1 week time, my lord. He is out of station, my lord. In the meantime, defect we will remove, my lord.
55.
Yes.
19874.
No.
208. Oh, sorry. Oh, sorry.
List on 3rd May. Defects be removed.
Item 56.
55th, 25th April, my old pens.
Right.
Item 57.
57, 58, 59, 60, 61, 62, 14th September.
All right.
And also 63.
63, 14th September. All right.
Item 64.
Outsourcing 8th August.
All right.
64 and 65, sir.
Both. All right.
Good.
Item 66.
66 similar matter in WA 193 of 2023, Lordship has issued notice and fixed to 26 June 2023.
All right. 26 June, stay list along with WA number
193 of 2023.
193 of 23. Right.
26 June 2023 date.
Right.
Item number 67.
None. 67 is state of Orissa.
That transport. Passport. Passport.
Okay. Pass on.
Item 68.
68 my 14th September.
14th September.
Item 69.
69, 70, 71, 72, 14th September.
Item 73.
73 my Sartapad 8th May.
8th May.
Item number 74.
Rehabilitation asset 30th August.
30th August.
Item 75.
Sartapad 8th May.
Item number 76.
76 my job contract 14th September.
Item 77.
77, my lord, before my learned senior start, your copy of the appeal memo.
Yes, my lord, I will serve in person.
What is the matter about?
That's matter, my lord. The department has imposed with the punishment that has been set aside by honorable single judge. Punishment imposed in the departmental position has been set aside at phase 22 is the impune order. I'll give a copy of his appearing.
Yeah, what's the ground, sir?
3 grounds are there. First ground, my lord, honorable single judge has held on retirement, the proceeding is deemed to be closed.
Yes.
Your lordship can find it from page 28.
No. Only because the squad report did not exist, it says. There was no squad report, therefore.
No, my lord. That was supplied, that was our also ground that has been supplied to him. Your lordship, you can find it from page 28. Page 31. Lordship, got that's the
Yes.
a legible copy of. Kindly refer to at the above note, the copies of squad report of SN for so and so and envisions has been supplied to Sri Das.
No, but this simply says a letter which says that. Do you know it actually supplied?
Your lordship, you can next page 32.
No, the same type copy of that.
Then I'll give the details when that has been supplied and all.
Page 97 of the read petition, it has been admitted. The read petition page running page 97. It has been admitted before the Honorable Tribunal in a content petition that the squad never visited to those spots. And the squad report is not exist at all. Basing on that, my lord, the order has been passed by the Honorable. Page 97 of the read petition. The second paragraph.
And second ground, my lord, that in our inquiry, that neither the inquiry officer nor the departmental disciplinary authority has relied upon that squad report.
No. Page 44 is the
Your
inquiry
lordship,
report.
page
That
40
has been relied upon.
42 is the inquiry report.
Page 44 of the read petition, the inquiry report, specifically the inquiry officer held, even though a straight line cannot be drawn, but basing upon the report submitted by the squad, the exact wording, my lord, page 44 running page. Even though a straight line cannot be drawn regarding the maintenance cost of the plants, but taking into the area found on measurement, the witnesses of the secretaries and the visiting report of the squad, I found that the plantations have suffered drastically and haphazard maintenance has been taken out. And the earlier read petition, comment, you supplied the squad report of Dantiaman and Sarat, those two TRCS. Now they have admitted in 97 that never visited, the squad never visited those two spots.
Yes, Mr. Kuntia.
I'll call this matter next week. I'll satisfy.
Why?
Why? I'll satisfy my lord that whether that squad report has been relied upon.
Your own letter. This is a letter written by
I'll
your
this-
deputy secretary.
Yes, my call this matter tomorrow. I will go through this.
All right. At the request of Mr. Kuntia, let's tomorrow.
Tomorrow, I'll say.
Item 78.
78 March 14th September. 78, 79, 80, 14th September.
All right.
Item 81.
81 my lord, 8th August. Outsourcing.
Item 82.
82 my lord, Sartapada 8th May.
Yes.
Item number 83.
May it please the lordships. This matter relates to the closing down of the pediatrics department in SCB and shifting it to the Sishu Bhavan here. And because of that, patients are suffering because the super specialization, consultation and other facilities are not available. On the 19th September, Lordship directed me to file an affidavit.
We have filed affidavit.
I filed affidavit on the 6th of December and gave a copy on 5th December to the government.
Have you seen this affidavit, sir?
Yes, my affidavit I filed on 6th December.
No, no, my affidavit have you seen? My lord is asking.
No, I just got it now. I haven't seen his affidavit, but Lordship may permit me to place my affidavit if your Lordship's
You
permit.
have to see his affidavit, you have to respond to it, sir. An affidavit dated 6th April 2023 has been handed over today in court by learned additional government advocate. A copy thereof has been supplied to the petitioner in person, who appears in person. He needs time to respond to the said affidavit. He list on that we are. 17 July.
With my affidavit, I had filed in December, my Lordship may take me.
Yes.
Item number 84.
My lord, item 84, conducting counsel, Mr. Sao is out of town, so I request this matter be taken up next week. Just a short adjournment, madam. Can be taken next Monday.
Once for the appellate state been some personal difficulty.
There is no urgency. It can be after vacation. It can be taken.
10 July.
10th July.
Item number 85.
Please, your Lordship. Last occasion, Lordship directed to submit the audit report as well as the what step taken against the headmaster, where she sexually act against the students of the school, and discipline proceeding already initiated, and committee report that fact is correct. To that effect, Lordship directed to file the audit report as well as the what step taken against the headmaster, madam.
And last order is that 17th January 2023, Lordship had directed to file an affidavit by the state school and mass education department as.
Yes.
So I need only 7 days time, madam. So these files have been transferred to us, madam, just 1 week before.
Mr. Kunti, I learned AGA seeks for some more time to comply with the order dated 17 January 2023. Full stop. As a last chance, time is granted up to 22nd June 2023. Comply with the above order. And file there. Is there. Response thereto, if any, be filed by the petitioner before the last date. List on. June.
Item 86.
May please, your Lordship. But here the 86 relates to the pleadings are complete, my lord. We filed a rejoinder as undertaken on the last date. We filed a rejoinder to the counter affidavit as well. But
you filed your rejoinder.
I filed my rejoinder.
Maybe posted to any other date for final hearing.
Rejoinder has been filed. Is there an interim order?
There's no interim. There's no interim order, but they have not been conducting any mining operations in view of the pendency of the writ petition.
But there is no interim order as such.
17 July. No, 17 July.
Item 87.
Writ appeal is against the judgment, the Honorable Single Judge, wherein an order of termination has been set aside. During the probationary period, our stand was that it is not punitive and not, there is no stigma associated to it. So therefore, no procedure was to be followed. But now something has happened, Lord. The writ petitioner has now joined the Odisha Administrative Service.
Oh, I see. It's all infractions then, sir.
No. See, he is interested to come back to the bank service. He is not. Well, yesterday also I have asked him, why are you coming back? No, sir, if I go there, I will be a scale 4 officer. I am not accustomed to this type of.
No, when will he come? Who knows?
No, because it's subject to, my lord.
No, why should we decide? If he continues in the tribunal, we don't have to decide this.
No.
Where is he joined?
He is now, as a Tahsil now, he's been transferred, order of transfer. Now he's continuing in Talche. He's a Tahsildar or something like that.
Oh.
Revenue officer.
Talche, revenue officer. Orissa Administrative Service.
It is stated that the opposite party has now joined the Odisha Administrative Service. As posted as Tahsildar, Talche.
Exactly. Tahsil revenue officer at Talche now.
And is posted revenue officer in Talche. Paragraph. Counsel for the respondent, however, insists that the matter has not become infructuous. Full stop. He nevertheless wants to take time for instructions. July 25th.
88.
88, my lords, respondent number 6, private respondent. Main contesting party filed a counter. Lords, I have not received the copy of the counter, my lords.
My lord, I am from the BC, my lord. I am for the opposite party number 6. I had filed the counter. I will have the copy, my lord.
He hasn't got a copy. Whom have you served it on?
He will serve.
He will serve. Achha. Copy of the counter affidavit of opposite party number 6 be served. So respondent number 6. He served on counsel for the appellant during the course of the day. Response be filed before the next date. List on 25th July.
Must interim order to continue.
Interim order to continue.
Obliged.
Item 89.
May it please, Your Lordship. Your Lordship, this matter relates to the enrollment fees of the Bar Council, and the pleadings are complete. We have also filed a rejoinder.
Your Lordship, appearing for Bar Council of India, behalf of Mr. Bose, I am appearing here. My lord, praying for an adjournment regarding this matter, my lord. Mr. Bose is out of station, my lord, for this week. Kindly taken up any day.
He's appearing for Bar Council of India.
Yes, Your Lordship.
It is stated that Mr. Bose, learned counsel appearing for Bar Council of India, is in some personal difficulty today. Have you filed a reply, BCI?
BCA has not. Bar Council of Orissa has. BCA has not.
Last opportunity BCI to file a paragraph reply to the writ petition.
My lord,
is 1 week prior to the next date. Rejoinder, if any, be filed for the next date. List on. July 27.
Your Lordship, my only difficulty will be a batch of academic year will be over by then. Again, a lot of people will come for enrollment by July, paying the this high amount of fees.
By July they come? I thought the law results comes later.
By
Usually
July,
September only.
By July it should come.
The petitioner is right, my lords.
Sorry?
My lord, the petitioner is right. My lords, it's a PIL, so we should be very much.
Yes, Your Lordship. And also the Kerala High Court recently has given an interim order in such a PIL.
All right, 26 June.
Obliged, Your Lordship.
Obliged, Your Lordship.
I'm obliged.
Item number 90.
Two applications are there, my lord. The
My
first
lord, in
item, my
that
lord.
case, your lordship must remember, maybe remembering that matter. The Pollution Control Board has submitted a report stating that there is no health hazard. And this, on the same cluster, many Blackstone queries are in operation. And this particular, so out of 13, only 6 in respect of 6 queries, your lordship has granted interim order and challenge has been made by the petitioner. And we have already completed the auction process and we have already obtained the permission from the SIA. The Tahsildar already permission from the SIA. And when we are going to grant the lease, this matter was, PIL was filed and several cases earlier to this PIL was also filed, and your lordship was pleased to grant a stay order and ask the Pollution Control Board to submit. The Pollution Control Board has
already submitted the report, my lord.
That is most important. And in spite, and if that report is taken into consideration, your lordship will find that the allegations made by the petitioner are all baseless and motivated. There is no at all health hazards. Nothing is sort of that.
What does your affidavit say?
My lord, we are the villagers, my lord. We want that, my lord, those hillocks, my lord.
They
Those
are
Blackstone quarries be operated,
petitioner.
my lord. Because illegal mining activities are there, my lord. And the village.
Sir, your lordship's previous order, let's me kindly see. I'm in the second item. But it's a glaring picture that has been given before lordship. The physical presence of the place as such. But the huge amount of dynamites are being used to blast the rocks. The entire agricultural land has been denuded with the sand and all those particles. Some village house walls has been cracked, but they visited without intimating any one of the villagers. The Pollution Control Authority, as per lordship's previous order, but they visited some house.
A joint committee was constituted. They visited
No,
the
you
spot
did not
one by
invite
one.
the villagers. You did not invite
all
the
the
villagers.
villagers were present during the course of an inquiry. That
Is there any signature anywhere taken?
no
of any of the
signature. How can
petitioners?
the hundreds of villagers and
No, petitioners.
petitioners?
We are only 5. Our house and land
There
has
was
been
no
affected.
such specific direction. The petitioner will be informed. Your lordship has constituted a committee. Committee went to the spot in presence of the villagers. All these matters were inquired of. Whatever the allegation my learned senior is now saying.
Rejoinder, I have
Everything.
given the photographs. Lordship, kindly see.
And those photographs were already there prior to the investigation, and your lordship has
Kindly have a look at the photographs.
now.
There's absolutely
Your lordship may see there are a cluster of stone quarries, 13 stone quarries. Out of
22 stone quarries.
no, for that in that particular Mauja. I am stating that in that particular Mauja.
My lord, out of 22 stone quarries, 2 have a valid license, valid consent to operate, my lord. That period is also over, and we have already task force has been formed, and all illegal stone quarries have been stopped. And this it is still
The road is absolutely.
my lord, it is still ongoing, my lord. As per my instructions subsequent to filing of this
Can you show
affidavit,
us a corresponding photographs then?
we have also, my lord, filed the photographs of
Where is that?
in the report, my lord. So for those photographs, they have annexed, my lord. Those who have visited and no such crack was found. That is our.
No. With the rejoinder, they filed photographs.
Yes, yes.
Have you seen them?
Yes, my lord.
Ah,
Those photographs, my lord, we have visited, there was no cracks, my lord.
No. You have
29th March. The photographs are dated 29th March, sir.
that itself also shows that. Their own photograph also shows that.
On 20,
I have in addition to give them
on my
other
lord,
photographs.
22, 2023, the joint committee, action from both from agriculture officer and from the health department and the scientists of the pollution board, all of them have visited the spot.
Where is the report?
And the report is annexure D series, my lord, of my affidavits, my lord.
Which affidavit, sir?
Additional counter affidavit, my lord.
Page 8, my lord, in that additional affidavit.
Connected matter. What is the date of this affidavit, sir? 7 January 22.
24/1/2000.
23.
My lord, 22nd February 2023, the inspection was made.
No. Your affidavit is 2nd March 22, 23,
Yes, affidavit is second.
23. Have you seen this affidavit, Mr. Mishra? 2nd March 23 affidavit.
Yes, I have filed a reply to that. I have also indicated all those things.
And I
This
have not
report
received-
of
I have not
looks at.
But I have not
Indicate that any of the petitioners were informed about the visit to show where the cracks has been done, how it has affected the agricultural land. My lord, I have not received subsequent reply to this affidavit.
All right. You say an affidavit
My lord,
has
may
been
kindly
filed
consider
on
one thing, my lord.
April 2023 by the petitioner in response to the affidavit. You say in writ petition 72762 of 2021, a rejoinder affidavit has been filed.
The file is subsequent.
By the petition number 1 in response to the counter affidavit of opposite party number 6. Full stop. This affidavit encloses photographs of the relevant places. Counsel for the SPCB, right? You're for the SPCB.
SPCB.
Seeks time to examine the said rejoinder affidavit.
My lord, may kindly consider one thing, my lords. These are some of the queries within a particular cluster. Others are functional in the same area. And these people, my specific allegation is that they are the local villagers. They are involved in illegal minings. And they want that these queries should not be settled in favor of and government should earn some revenue.
No, they should arrest us if we do illegal.
We have already lost criminal cases against many others. And what has happened, my lord, because in view of the stay order, in the fag end of the auction process, the matter is stopped. And we pray that because all these things are already taken care of earlier in a separate writ petition also.
So this is same order continues.
Lordship may keep it to after next week or 1 week after, because the interim order is come. We have filed a vacation of stay, that is IA number 17114 of 2022.
That also I have replied.
Yes.
17th April, next Monday.
17th.
Interim order to continue.
Interim order to come.
17th April.
Quick list pastor matter item number 25.
My lord, in this case, I appear for the petition and today I am filing the appearance memo, my lord. I know.
25.
Item 25.
Who's for the other side? It's not come up for hearing yet. Yeah, it's not come up. Yes, sir, tell us.
Some defects are there and that will rectify.
What about the others in the batch? There are other petitions in this batch.
This is only my, I do not know about other batches.
No, you should know this.
Your
Age from 58 to 60.
Item number 25.
No. If it has already come before the court, what is the order we have passed? You do not know.
I am appearing today, my lord. I have no knowledge. I am just today I am appearing for the appellant.
25.
25. Defect, I will ask him to serve a copy on this.
They have not served a copy on us.
Yes, the defect, what I marked that, the copy has not been served. I asked the person who has engaged me to serve a copy to my lawyer.
No, you're for the Board of Secondary Education.
But that matter, I don't know what is that matter. Copy is not served on
No.
me.
1531 of 2022. The appellant is the Board of Secondary Education.
1531.
The appellant is the Board of Secondary Education.
1531 has no connection with this matter.
Then item 27 is the same, that Board of Secondary Education.
We are in 25, my lord.
25.
25.
1528. Sorry.
I don't know. I was not there.
Board of Secondary Education.
So this same thing is, this is that,
8th July.
we've already dealt with this matter. Again, the same thing is coming. We've dealt with the writ appeals of Shakti Ranjan Mishra. Are you sure this matter has not come up earlier, sir?
It's first time it has come up.
Sounds so familiar. Counsel appearing for the. You say a copy of the writ appeal be served on counsel appearing for respondents 1 and 2. What about respondent 3?
My lord, notice to go, my lords.
No, I'm not able to understand. So, what is your grievance against the impugned order? What is your grievance against the impugned order? What is it?
Because there was what I've gone through little. There is about the reconstitution of the governing body that was made, and thereafter it was passed. That's why we approached, and the Honorable Single Judge dismissed the writ appeal application.
Which is the page? Which page is the order? Impugned order?
In fact, I need a little time also preparation. I've received it today morning. Yes, I have not gone through it.
There seems to be a batch of matters or something. Judgment prepared in separate sheets.
Oh, yes, sir. In the writ application, it appears there is a batch of cases.
Deciding.
It appears, my lords, the WBC 21367 of 2014 was an employee of the institution who was functioning as the principal. His service was terminated. His cases are completely different. But all the matters were heard together by the Honorable Single Judge. And one common order was passed.
But this order was passed when?
The order was passed, my lord, on 18th of October 2022.
So today we are in April. What has happened in the meanwhile?
That's a limitation. And I was there along with that, my lords.
No, you're agreed because the governing body has been asked to be reconstituted, correct?
Yes, ma'am.
So that was asked to be done quite some time ago.
I need little time, my lords.
All right. Counsel for the appellant needs more time to prepare and address arguments. 21st June.
Pastor matter item number 67.
67 outsourcing employees regularization matter 8th August.
8th August.
Over.
All right.
LLC 889 of 2019.
But this is a case for questioning of criminal prosecution on the ground of compromise. Affidavit is at flag B, my lord. My lord's signature appearing for the opposite party is on VC, my lord.
All right. Counsel for the opposite party number 2 confirms that disputes have been settled between the parties. An affidavit to that effect has also been filed. That view of the matter taken prayer clause and all proceedings consequent thereto are hereby quashed.
Obliged.
Item number 2.
Obliged.
Item 2.
None appears dismissed.
Item number 3.
Same order.
Item number 4.
In item 4, I'm in VC, my lord. Here the question is, I have prayed for a quashing of the FIR, which was registered under several sections of IPC, and the most important section was section 20 of the Cigarettes and Other Tobacco Products Act, my lord. Here what has happened, I was arrested, I have been released on bail, and my confiscated goods has also been released, my lord, and the godown has also been released, my lord. Here, my main ground here I've taken is, your lordship, kindly come to page 6, para 11 of my paper book, my lord. The FIR was lodged on the ground that I was selling tobacco and gutka, my lord. Where gutka is a banned item as far as Orissa is concerned. And page 6, para 11, my lord. That the samples drawn and sent for chemical examination, it was seen that there was no narcotic contents in the samples seized. And the seized samples were only pan masala and not tobacco as presumed by the department. The report further stated that the sample is fit.
Maybe there'll be a closure report, you never know.
No, my lord, not yet. The charge sheet has not yet been filed. Closure report.
So it will get filed in due course, sir. Nothing.
Because
There's no stay order passed here.
No. What has happened? This morning I inquired from the client. He went to the court and found out the charge sheet is yet to be filed, neither the closure report, my lord.
That's okay. Once we dispose of this, it will get filed, sir. You say it must be waiting because of this petition. By now you would have got discharged.
But a stay has not been granted in this.
I know, but what happens is people simply say that it's pending in the High Court, don't do anything. This is the problem. Permitting the petitioner to urge all pleas at the appropriate stage, the petition is disposed of. All right.
Item number 5.
None appears dismissed.
Item number 6.
Same order.
Item number 7. May I please, your lordship, on behalf of Mr. Rajiv Lochan Patnaik, permitted to withdraw, my lord.
Okay. Memo taken on record, disposed of his property.
Item number 8.
None appears dismissed.
Also, item 8. Item 8, your lordship. Liberty may be granted to raise all the pleas.
All right. Permitting the petition, please.
Item 9.
May I please, your lordship, I am on behalf of Mr. Mahesh Das, permitted to withdraw.
All right. Dismiss this withdrawal.
Right.
Item 10.
Item 10, my lord, I am 10, item number 43. Both are registered of the same GR case. Your lordship may grant me liberty to raise all the points before the trial court.
All right. Permitting the petition.
10 and 43.
All right. 10 and 43.
Item 11. 11, my lord. The annexure 1, the petitioner challenged the discharge petition rejection order, my lord. And the dispute between the parent-teacher association and the present petitioner is the president of parent-teacher association as per the Act of Orissa Right of Children to Free and Compulsory Education 2009, my lord. And due to misappropriation of school funds for development given by the government, the informant has lost FIR, and the present petitioner opposed for his misappropriation, and for that reason also a writ petition also pending before this honorable court, my lord.
Anyway,
And my lord, now in the meantime he has filed a criminal case against the president of Parent Teacher Association, and the informant is the convener of that Parent Teacher Association, my lord. And that's why I'm.
It's all right. Permitting the petition to raise all pleas in the appropriate stage. Petition is dismissed. Right.
Item number 12.
None appears dismissed.
Item 13.
Same order.
Item number 14.
Same order.
Item number 15.
15 may please, my lord.
My lord, petitioner has filed this application challenging the order of cognizance which has been taken for various offences of the IPC, including section 307. My lord, may kindly turn to Annexure 2 series. Is the medical report of all the injured persons. My lord, there is no injury. There's no injury at all to any of them. My lord, section 307 cannot be attracted in this present case to challenge the order of cognizance on that ground.
Permitting the petitioner to raise all pleas with the appropriate.
Obligation.
All right.
Item 15.
None appears dismissed.
Item number 16.
Same order.
Item number 17.
Same order.
Item number 18.
Same order.
19.
Then liberty may be permitting the petitioner to raise all pleas.
Item number 20.
Same order. Sorry, none appears dismissed.
Item 21.
Same order.
Item 22.
Same order.
Item number 23.
Same order.
Item number 24.
Same order.
Item 25.
Same order.
26.
Put down the IA and say none appears dismissed.
Item 27.
None appears dismissed.
Item number 28.
Same order.
Item number 29.
Same order.
Item number 30.
Permitted to withdraw.
Dismiss is withdrawn.
Grant liberty to if.
All right. Permitting the petitioner to raise all pleas the approach.
Obligation.
Item 31.
My lord, in this case, my lord, the petitioner challenging the order of cognizance, my lord. My lord, fact of the case, my lord, the check was bounced due to drawer signature incomplete, ineligible, differs required, my lord. My lord, the check has been stolen, my lord, by the neighbor, my lord, and that has been deposited in the bank, my lord. Therefore, thereafter, the petitioner made representation to the bank for a stop payment, my lord. My lord, without knowing the factual aspects of the case, my lord, the loan SDGM has taken cognizance, my lord.
It's all right. Permitting the petitioner to raise all pleas the appropriate stage. The petition is disposed.
Item number 32.
None of it is dismissed.
33.
Item 33, your lordship, the noting that it should be criminal revision. I will take a step to conversion.
All right. Counsel for the petitioner seeks leave to withdraw the present petition, liberty to file an appropriate petition to the courts. Disposed of withdrawn with liberty to pay.
35 copy may be permitted to.
34 also, is it?
No, certified copy.
Urgent copy, please. All right.
Item 34.
Unappears dismissed.
Item 35.
Same order.
Item 36.
Same order.
37.
Same order.
Item number 38.
Lordship, item 38, liberty may be granted to raise all the points.
All right. Liberty.
Lordship.
Item number 39.
Item 13 on behalf of Mr. Anand Pragada, I may be permitted to withdraw.
Dismissed as withdrawn.
Item number 40.
None appears dismissed.
41.
Same order.
Item number 42.
May I please, your lordship, item number 42 on behalf of Mr. Pratik Das, no instructions.
No instructions dismissed.
Item 44.
May I please, lordship. This is a complaint case. I am challenging the complaint case itself. The first complaint was lodged under Annexure 2 at page 27, page 17, my lord, and the complaint was dismissed. Thereafter, once again, another complaint for the same cause of action was filed at page 10 under Annexure 1. That for the same accused person, same cause of action. And the London Magistrate resorted to 156(3) and report investigation was made. And after investigation, closure report was also filed. That is at page 27, my lord. Still then, the Learned Magistrate asked him to file the objection to the file to protest petition. That has not been done, and the case is running. And over and above, my lord, on 8th of 2019, compromise was effected between the parties.
That you can bring it to the notice of the court there.
Well, it was brought, it was recorded, my lord.
Where is that?
My lord, I have stated in para page 6, last line. Paragraph 8.
What happened? I mean, when you placed it before the court, what happened?
No, he is waiting.
No.
To be filed.
You filed an application placing the compromise before the court.
What I primarily used to be issue notice to the so that he can come and quash the proceeding.
Not necessary. You say if indeed there is a compromise reached between the petitioner and the opposite party, then petitioners and the opposite party, then this can easily be placed before the trial court for appropriate directions, permitting the petitioners to do so. The petition is disposed of. Right.
One little prayer, my lord. In the meantime, he has issued an NBW in the defunct 1cc. Then you will say no persuasion till the application.
That's a separate issue, sir. Yes.
Item 45.
None appears dismissed.
Item number 46.
Same one.
47.
Same one.
Item number 48.
Same one.
49.
Same one.
Item 50.
Same one.
51.
Same one.
Item number 52.
Same one.
Item number 53.
Same one.
54.
Same.
Item 55.
Same order.
56.
Same order.
Item number 57.
Here, my lords, amount has been paid. Matter has been compromised.
All right. And counsel to the petitioner informs the court that pursuant to the agreement at Annexure 2, the entire amount. But how do you know that? Is there an acknowledgement?
I'm sorry that I have not, but the lordship may record the statement. The same compromise petition has been filed before the trial court.
Yes. Entire amount has been paid. Copy of the compromise petition be, you say paragraph, no, just start like this. You say Mr. Ireland, senior counsel for the petitioner states that pursuant to an agreement between the parties, the entire amount due to opposite party number 2 has been paid by the petitioner. The relevant documents in proof thereof be placed and recorded for the next day. Let's turn. Let's proof the roster page. On 2nd May.
Much obliged.
Item 58.
58, my lord. I may be permitted to withdraw to file a better application. The certified copy may be returned. Because it is
Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file a better petition. The originals be returned subject to substitution with attested photocopies.
I am for the opposite party.
All right.
The matter become infructuous. That the very same order has been challenged in a criminal revision 262.
Then no need for liberty. Just say counsel, the petitioner seeks leave to withdraw the present petition. Dismiss is withdrawn. The originals be returned subject to being substituted with the attested photocopies.
Actually, it is infructuous on his submission. Your lordship may record that. Otherwise, I may be prejudiced because I.
Right. In the beginning, you say counsel for the opposite party states that the petition has become infructuous. Then you say he seeks leave to withdraw. Dismisses. All right.
Obliged.
Item 59.
None appears dismissed.
Item number 60.
Same order.
61.
Same order.
Item 62.
Same order.
Item number 63.
I'm for the 62.
You are in 62.
Yes, that one vigilance case has been made before the father of the petitioner, under section 13(2), read with 13(1)(e) of the PC Act. And the total amount has been freezed. So petitioner wants to release of the amount from the freezed accounts.
It's a DA case, my lord. The property, the accounts which has been seized, that is in relation to, that is connected to the main accused. So it's a DA case, it cannot be released at this stage in view of the judgment of the Honorable Appeals Court.
The matter is still pending.
Still
Yes,
pending.
sir.
You say since the criminal trial is still ongoing, it is not possible to accede to the prayer of the present petitioner for release of the seized amount at this stage, permitting the petitioner to renew the prayer at the appropriate stage. If permissible in accordance with law, the petition is disposed.
Item number 63. 63, no instruction. Liberty phrase cause of action survives, man.
No instruction means no instructions.
No liberty to file a application if cause of action still survives.
Not.
Item number 64.
64, please, my lord. It arises out of an enforcement of the bank's liability against the complainant, my lord. There are 5 cases, 4 against bank officials and 1 against the directors, my lord. This has a long history, my lord. The complaint case was earlier lodged against the directors, which was dismissed. Then, my lord, in consumer forum, the complainant who was a loanee went, and National Consumer Forum also lost. Then a civil suit is also pending. So in that background, and it arises purely out of a forward contract, my lord, that hedging of the foreign exchange, my lord, in a future point of time, your lordship knows. My lord friend is appearing for the directors.
I'm appearing for the director. I'll submit to your lordships after. He is appearing for individual officers, 4 of them.
And we are 4 individual officers.
No, but has the company been made accused?
No, Lord, no, the company
has filed the case.
I'll tell your lordships. Over
the company is filed against all of you.
No, not that company as well. I'll just tell your lordships. There was another company who had a contract with a bank for a hedging contract. It is a highly technical hedging contract. Means it's like an insurance. You gain, you lose for the future. And that hedging contract, after the hedging contract, the bank withdrew some amount for which first this company, when the complainant company filed proceedings before the learned magistrate for taking cognizance, and the learned magistrate directed for registration of affair, and against the 4 officers represented by Mr. Mahanti, the case was registered. That was his case. But thereafter, Lord, what happened? He filed a separate complaint against all the 9 directors of this national level bank all over the country, against the second complaint against me and the same facts. He filed a second complaint. The learned magistrate in the second complaint dismissed the complaint against us, saying that no case is made out against the directors, and the company is also not a party. Then when the lordships have decided in the mining cases that and the company is not a party, then cannot. But that's another issue of law. But the fact remains, when the complaint was dismissed, Lord, I'll describe him as the complainant company filed a revision before the learned district judge against this order. The learned district judge dismissed his revision. That means the dismissal of the learned magistrate was affirmed by the learned district judge. Thereafter, my lord, a third complaint was filed against me, in which me means the directors, all the 9 directors, against which again the learned magistrate has directed to take to register a case. And that is the reason I have come before lordships. The 4 officers have come before your lordships in that 4 proceedings, saying that
this third complaint, was it against the company or only against
the directors, against the 9 directors, against the 9 directors without the company, and after the dismissal of his second complaint on certain facts.
No, he's the complainant, is it?
He is not a complainant.
No, I am
the
complainant.
So who's the complainant now?
The complainant is an opposite party. Notice
represented or not represented?
A notice has been issued. In my case, my lord.
Notice has been issued in all the cases.
Our cases probably. My lord, he is Mr. Parthasarathy. If lordship sees the CRLMC 460 of 2017, there are some appearances for the respondent. So, my lord, apart from that facts, my lord, there are some other facts would be relevant. Also, he had filed a writ petition, writ was dismissed. He had filed before the National Consumer Commission, National Consumer Commission dismissed. He filed a review, dismissed.
No, only thing is here, we have to hear the informant.
Yes,
Complainant.
truly. Your lordship may.
They are not there.
They are not present before your lordships now. In the if your lordships, the names are there in that third case, if your lordships, which I am filed, 460 of 2017. There are some lawyers appearing for them. Part 39.
They are appearing in all the cases.
All right. You say counsel whose names are shown as appearing for opposite party number 2 complainant are not present when the matters are called out today. The registry will telephonically inform them to remain present before the roster bench on the next day. Interim orders to continue. List on 3rd July.
Grateful, sir.
In all the cases.
All cases.
Obliged.
Item number 65.
Lord, 65, not the complaint case was lost. Your lordship has already reached covered. Company is not a party. Several decisions your lordship has given, including one. Good order to them. May I pass one such order?
Yes, yes.
It is state over second. I've got a more case. A more case could have. Right from Anita Hada to your lordship has elaborately discussed several judgments by this time.
Correct.
Your lordship has given.
So I think this first
as single judge.
In July, order you pass. Quashed.
Item 66.
Item 66, my lord. Here, my lord, the petition challenge 125 proceeding filed by the opposite party number 2, my lord. But in fact, my lord, what happened there, the petitioner filed an objection, my lord, to that respect, my lord. The objection was rejected by the Judge Family Court, my lord, Baripada. Thereafter, my lord, granted interim maintenance to the wife, my lord. Challenge that petition come before the RC, my lord.
All right.
And somebody appear for the opposite party, my lord.
What's the amount awarded?
3,000 for the...
Rupees 3,000 per month has been awarded as interim maintenance. And there has been... and the opposite party wife, opposite party number 1 wife, right?
My wife 1
is has the custody of opposite party number 2 daughter.
My lord.
Son.
So for 2 is 2,000, my lord.
For whom 2,000 as interim maintenance has been paid, considering the amounts to be insignificant and further that they're only the nature of interim maintenance, the court is not inclined to interfere.
Since your order is the trial court directed to proceed.
It will be open to the parties nevertheless to expedite the proceedings in the trial. A petition is discussed with the above sections. Right.
67.
Item 67, my lord. Petition filed the present case, my lord, for quashing of cognizance, my lord, and stay has granted a notice issued. My learned friend appearing for the opposite party, my lord. I add, since land dispute there, the petitioners are neighbor of the complaint, my lord. Initially, complaint case was filed. That was sent to the police station for registration of the case, my lord. Police submitted a final report. Fact is not true, my lord. Thereafter, instead of filing protest petition, see the opposite party to straightway, my lord, file the another 1C case, my lord. I advise my clients well to compromise matter since they are laborers, my lord. Can take up another date, my lord.
All right. Mr. Ragara states that the parties are exploring
Yeah, I'm
the
for the
possibility of
opposite party
compromise. This is not objected to by counsel appearing for opposite party number 2. Let's move for the roster bench on 2nd July.
Stay interim order to cut. Obliges.
Item number 68.
May I please roster? All these 4 cases, 68, 69, 68, 69 and 71, 4 cases filed, the malafidely by the at the instance of the employer, my lord. Once I was reinstated after the illegal termination from service. Now they anyhow want to club me in the police cases, and this is one of such cases. Here, my lord, from the itself, the allegation from the FIR itself is clear that no case is made out against me. Somebody has called in the mid of the night, telling some filthy language, and neither this is my phone number. They say that the person who called me is a henchman of me. That is the only allegation. And
There is no interim order here.
no interim order.
Okay. Permitting the petitioner to urge all pleas at the appropriate stage. The petition is disposed of.
No 41 notice arrested me.
It's all right.
All
58 to 71.
Yeah.
Item 72.
May I please, Your Lordship? May I kindly taken up this matter after, on next week?
Why?
Madam, because Mr. Das is not present today, so that's why.
No.
Yeah.
Your Lordships, I'm appearing for the opposite party. It's an old application, Your Lordship, challenging the recall order of under section 311. Just to linger the proceeding, this case has been filed. Accused statement has already been done, my lords.
Oh, statement the accused defense has already been recorded. In that view of the matter, court does not consider find any ground to interfere with the impugned order passed by the JMFC Bhubaneswar 11 January 2019 in 1 CC number 1884 of 2017, declining to entertain the petition filed by the accused for re-examination of the complainant. April 2019. As noted by the learned single judge. The complainant was partly cross-examined by the defense on 14th May 2018 and after a gap on 20th December 2018. Stop. At the fag end of the trial, an application was filed which would only delay the matters further. Consequently, the court is not inclined to interfere. The petition is dismissed. The interim order is vacated. Right.
Item 74.
Yes, Lordship.
74.
None of this dismissed.
Petitioner is challenging the cognizance order dated 8/4/2015, my lord, implicated in a case on section 366, 376D and 506 IPC. There are 4 accused persons in that case. The 3 accused persons are already been acquitted in that case.
So you can always point it out, sir. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is dismissed.
Item number 75.
None of this dismissed.
Item 76.
May I please, Your Lordship? The petitioners have made prayer for quashment of FIR and inter-criminal proceeding pending against them. The petitioner no way connected with the family of the informant and not coming within the ambit of the section 498A of IPC. So far as 498A is concerned, husband or relative of husband of a woman subjecting her to cruelty. Therefore, as the petitioners are outsider, the offense alleged to have been committed under section 498A, 313, 34 of IPC, read with section 4 of DP Act is not made out, my lord, against the petitioner. And earlier this on hearing, this case was admitted, notice issued, and so far as IA is concerned, this honorable court was pleased to hold that no coercive action can be taken against the petitioner.
Is there a compromise between the parties?
My lord?
There's no compromise with opposite party number 2.
I have to take instruction as,
No, it's all right.
as to whether there has been compromise or not.
No.
I have no instruction, my lord.
Permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed. Interim order is vacated.
Item 77.
Item 77, Your Lordship's liberty may kindly be
All right. Permitting the petitioner to raise all pleas.
78.
None of this dismissed.
79.
Yes, sir.
Please. Here, the petitioner is aggrieved by an order of cognizance taken against him under 498 IPC. While issuing notice, my lords, the Honorable Court
Thought there might be a compromise.
Yes, they are still living together in this under the same roof.
Let them file that before the court.
And in the FIR, my lords, there is no allegation whatsoever of 498.
It's all permitting.
Her entire allegation, my lords, is that I am not I am torturing, I am forcing him to give kids till a baby boy. She already has a baby boy also. The children are all studying, my lords.
All right, permitting the petitioner.
If your lordship sees the FIR, your lordship will find it's not a case under 498.
Permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed. Right.
Item number 80. Item 80.
None appears dismissed.
Pardon to make a mention, my lord, item 12. I was some late, my lord.
Tell us what it is.
Challenging the order dated, your lordship may kindly see annexure 4. My lord, initially a FIR was registered against some of against the OP number 2 for the offense under section 294, 337, 427, 323, 506. During the course of treatment, one of the injured subsequently died. Before died, the IO of the case submitted a charge sheet before the learned court below. After death of one injured, Prasanna Kumar Rautray, the petitioner the informant filed a petition before the learned magistrate to re-inquire the matter and directed for re-investigation. As because the person who died subsequently due to the same cause of action. Though the injured on 15/3/2018 could not given the evidence in time, and the earlier injury report shows that the injured has sustained one injury. That reason the learned magistrate dismissed the petition.
It's all right. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed.